So, as you know, I'm reading case law about workers' comp. I'm reading about different injuries that happen in the news. And then I'm also reading about injuries that happen in other states and how other states approach, work injuries and kind of looking how Ohio might approach that same kind of work injury situation. So I was reading about a case or a fact pattern that happened in California. So this is California. This is how California approaches it versus how Ohio approaches it. I don't know anything about California law. So if you have a California injury, you need to get a California workers' comp attorney. But nevertheless, so this injury happened. This guy was leaving a fire camp. I don't know what's a fire camp. I don't know. We don't have fire camps as far as I'm aware in Ohio. I'm assuming that has something to do with firefighters being in the fire camp so that they could go out and put out these big forest fires that happen in California because it's super dry. I used to live in California for a bit of time, so I kind of know. I've experienced that aspect of California, but I never was in a fire camp. I used to live in the Bay Area, but anyways, so what ends up happening? This guy he wasn't a firefighter. He was actually a cook in the fire camp, and he was leaving the fire camp, and the reason why he was leaving is he was going to make a personal call on the cell phone, and apparently he was so far out in the middle of nowhere that there was no cell phone coverage, and so he's on the highway or wherever, and he's making the personal call, and then he gets in a head-on collision, and then obviously suffers a probably pretty bad injury. So he files a workers' comp case, and again, I don't know how California treats things. Maybe they have an industrial commission type board as well, but files the claim. I think it must have been denied because then there's a case, and then the question is, did this California court, did they allow this as a compensable workers' comp claim in California? And so a little bit more facts. Again, personal call, leaving the work camp. It's during his off hours, so he's not on the clock. And then leaving the camp it's against policy to do so unless you have express permission, which he did not have. And drove his own car, so he's not driving like a work truck. So California ultimately allowed the claim, which is great for this injured worker. And they said California said this is a compensable claim because the employer should reasonably have expected that the employee would leave the job site to make a personal phone call. So that's how California treated that situation. I'm not confident Ohio would have allowed this claim. And the reason why is I've talked about in other videos, but there's something called the going and coming rule that applies. So generally, workers' comp cases, you kind of look, where did the injury happen? If the injury happened on the job site, then you don't have to worry about the going and coming rule. It's not going to come up. But if the work injury did not happen on the job site, but instead, happened somewhere else, and in fact, the person's driving, the going and coming rule applies. And so the going and coming rule basically says that, again, I've mentioned other videos, driving from home to work or from work to home or some permutation between, and you get injured, it's not a compensable claim. So it could be in your car, it could be, walking somewhere, whatever. Not a compensable claim. And it could be fairly draconian. They get kind of technical. They're like, well, if you, again, the fixed situs, i.e. the work site or whatever, it could change from week to week, day to day, and in the case of nurses' aides and home health aides, hour to hour or job site to job site. So, but in general, the going and coming applies, and then you got to see if there's an exception. I don't see an exception that would apply to this situation. The best hope that I could have for this person, if this is an Ohio workers' comp claim, is that he was leaving the job site, the fire camp, on some kind of special mission, so that the special mission exception would apply. And then that doesn't exist with these facts, but if those facts did exist, then it might be a compensable claim. For example, if he was told to, like they're running out of steaks to feed the firefighters, and so his boss said, "Hey, get in your car. Here's $100. Go to the nearest Walmart or whatever, Myers, what have you. Get a bunch of steaks and then come back. I don't know how much steaks you get with $100. I have no idea. Maybe not that much anymore with inflation, but nevertheless. So get in the car, go to Myers, get a bunch of steaks, and then come right back, and we're gonna cook them up, and for our firefighters once they get back from putting out the big fire at Alum Creek or whatever, or Cuyahoga National Park. So in that instance, you would say the special mission rule would apply because you're going on a special mission. So generally, anytime you're driving or you're leaving work and somebody says do this thing, you would argue that as an exception to the going and coming rule. But if that didn't really apply, then he's really doing a purely personal thing, and there's no benefit to the employer for him to make I guess you could, a satisfied employee, a comfortable employee, maybe that's a little bit benefit, but it's probably not much. The employee has no control over the employee or their car when they're on the highway, and the proximity to the job site. Well, it's not on the job site, it's not on the fire camp, and who knows, it could be miles away from the fire camp. So under that analysis, I don't see this being a compensable claim. So in California, compensable claim. Ohio, not compensable claim. And it's also, that kind of says something. California is generally a liberal state, liberal, and so the laws tend to be a little bit more generous, and you can kind of see how that is in this situation, whereas Ohio is a conservative state, and the laws are more geared towards, I don't know, you could say they're geared towards businesses or they're against injured workers. I don't know, but the bottom line is the rules are a little bit more conservative, i.e. they're not, you might get a benefit in Illinois or California that you wouldn't get in Ohio. So bottom line is, if you have, and I always say at these end of these videos, if you have a work injury, don't mess around. Consult with an Ohio workers' comp attorney. Ask your friends, family, neighbors, coworkers, whoever. Who do you guys use to represent you for your work injuries, or who do you know is good? And then call those people. Call a bunch of attorneys, and then find somebody you feel comfortable with. But get an attorney involved. Don't do this stuff alone. You're going to run into major issues. So you've been listening to Kip and Malek. Stay safe. Thanks for watching this video.